Okay, I'd like to call this meeting to order. This meeting is held in accordance with the Open Public Meetings Act 10:4-6 at SEEK. Annual notice having been forwarded to the New Jersey Herald and the New Jersey Sunday Herald and posted on the bulletin board maintained in the municipal building for public announcement. Will you please rise and join me in salute to the flag.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Sorella? Mr. Diamond?
Yes.
Mr. Kamic?
Yes.
Mrs. Crock?
Yes.
Ms. Snow? Mr. Taylor?
Yes.
Councilman Kukovic? Mayor Galati? Here. Chairman Ray?
Yes.
Mr. Mazaluski?
Here.
Mr. Wagner? Mr. O'Brien?
Okay. Minutes. A motion is in order to approve the minutes of the April 1st, 2025 meeting. So I have the motion to
So
approve.
moved.
I'll second it. Motion is second.
Mr. Diamond?
Yes.
Mr. Kamic?
Yes.
Mrs. Crock?
Abstain.
Ms. Snow? Yes. Mr. Taylor?
Yes.
Mayor Galati?
Yes.
Chairman Ray? Mr. Mazaluski?
Yes. Okay. Next item on the agenda is resolutions. The first resolution is Boaz Levitin. The hearing date was March 4th, 2025. Do I have a motion to approve that resolution? I'll make the motion.
Second.
Mr. Diamond?
Yes.
Mr. Kamic?
Yes.
Ms. Crock?
Yes.
Ms. Snow? Yes. Mr. Taylor?
Yes.
Mayor Galati?
Yes.
Chairman Ray?
Yes.
Mr. Mazaluski?
Yes. Okay, next resolution is E.G. Anderson, March 4th, 2025 is the hearing date. I'll make the motion.
Second. Mr. Diamond?
Yes.
Mr. Kamic?
Yes.
Ms. Crock?
Yes.
Ms. Snow? Yes. Mr. Taylor?
Yes.
Mayor Galati?
Yes.
Chairman Ray?
Yes.
Mr. Mazaluski?
Yes. Resolution is Devon Ram Under. The hearing date was March 4th, 2025. Do I have a motion to approve that?
Motion.
Second.
Mr. Diamond?
Yes.
Mr. Kamic?
Yes.
Ms. Crock?
Yes.
Ms. Snow? Yes. Mr. Taylor?
Yes.
Mayor Galati?
Yes.
Chairman Ray?
Yes.
Mr. Mazaluski?
Yes. Okay, fourth resolution is Joseph Leon. The hearing date was March 18th, 2025. Do I have a motion to approve? I'll make the motion. Second.
Mr. Diamond?
Yes.
Mr. Kamic?
Yes.
Ms. Crock?
Yes.
Ms. Snow? Yes. Mr. Taylor?
Yes.
Mayor Galati?
Abstain.
Chairman Ray?
Yes.
Mr. Mazaluski?
Yes. Okay, the fifth resolution is Stephen and Linda Baldini. Hearing date was March 18th, 2025.
So moved.
I'll second it.
Diamond?
Yes.
Mr. Kamic?
Yes.
Ms. Crock?
Yes.
Ms. Snow? Yes. Mr. Taylor?
Yes.
Mayor Galati?
Yes.
Chairman Ray?
Yes.
Mr. Mazaluski?
Yes. Okay, next item on the agenda, any correspondence? Any escrow refunds, we have none. Bills, do I have a motion to pay the bills? Mont McDonald, Dolan and Dolan, and New Jersey Herald, and Van Cleef.
Motion.
Second.
Mr. Diamond?
Yes.
Mr. Kamic?
Yes.
Ms. Crock?
Yes.
Ms. Snow? Yes. Mr. Taylor?
Yes.
Mayor Galati?
Yes.
Chairman Ray?
Yes.
Mr. Mazaluski?
Yes. Okay, next item is zoning officer report.
Nothing.
All right, very good, Bill. Discussion? Any discussion?
3 meetings in a row.
He's doing his job.
I know,
He doesn't
We'll go
have
for a
to
record here.
discuss anything.
Keep up the good work.
Yep. All right, any old business to discuss? I think so. Any new business to discuss? Next item on the agenda is a continued application. The first continued application is Sandra Georgie, 8 Oneida Ave.
The board heard this application at its meeting on March 18th. It was continued. There was public participation. I believe the applicant submitted the applicant's case and presented that in full. It was carried because there were some members of the public who expressed concern that their access rights might be affected by the application. The access rights, I'm sorry, that were created through easements were not specific in the sense, this is my understanding of the testimony and exhibits, that it was an easement for access, and as long as the applicant would not interfere with those rights, then I don't see an issue. If those rights would be barred, if there's a 25-foot easement by way of example, and you put a barrier over the whole 25 feet, well, that's an interference with the easement right. But if there's still an access ability to get down unimpeded to the lake, then that would not be prohibitive, what the applicant's trying to do.
Okay, well, I think the last meeting, we took all the testimony. We don't have to hear from the engineer. We don't have to hear from the architect. I mean, basically, we postponed this to see if you guys could come up to some type of an agreement with an easement. And if not, then we're just gonna proceed with it.
Yeah, and we were able to come up with a license as opposed to an easement.
Okay.
And it will renew annually, provided that proof of insurance is provided. Additionally, we had it drawn on the map where the licensed area was to show that we weren't impeding it. There were some trees that were planted on site that had to be adjusted. I have the engineer here to provide testimony with respect to that if you'd like to hear it. Otherwise, if anybody else from the public wanted to comment on it, we could do that. The license itself is in its final stages. It's been passed back and forth 3 separate times, with the most recent version being passed this evening. So we're just waiting to hear from them if they have questions or concerns. But aside from that, we presented all our testimony and exhibits.
Okay,
So we're good?
so, the public would have a chance to
Yeah.
speak, of course.
Okay. Does anybody from the public wish to comment on this application? Step right up. Yeah, you come here.
Okay, please.
It's easier to see, Corey.
Please raise your right hand. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
Again, your name, please.
Carolyn Ligori, Liguri.
Okay. You spoke at the last hearing.
Yes, I'm just want to make sure that the right of way is put back in the same condition. We're fine with that. So that we won't have to pay that. That's really my concern. Because it was just done, I think, a few years ago. Yes, right.
And what is the right of way comprised of now that might
It's
be disturbed?
the it's so the 3 houses that are down on the
No,
bottom.
what is the right of way?
So they go through her property, I believe, right? And the easement is through yours.
Yeah.
So
Is there
they,
pavement or is the?
Yes, blacktop.
So
They
if the
agreed last-
blacktop is ruined, you want it to be
Yes.
restored?
Oh, yeah.
they agreed to put it back, any damage last minute. So they-
Just wanna make sure it's final,
Yep.
Okay, all right.
That's it.
All right, thank you.
Thank you.
Anyone else from the public wish to comment on this application?
Just briefly.
How brief, Chris?
Yeah, that'll be a
Just
first.
To put on the record, that Mr. Beckendorf and I agreed that, a condition of the approval would be that we enter into the license agreement. And he's right, we are circulating the agreement. I have the 3rd iteration right here. I'm taking a look at it. We may not have it signed up tonight, but we'll get it signed up probably within the next day or so.
Well, Bill, that really doesn't affect us either way,
No,
right?
it
That has
doesn't. I
nothing
just
to-
wanted to have that as a
Yeah.
condition, and they've agreed to that, so
Okay,
thank you.
perfect. Anyone else from the public wish to comment on this application? Seeing none, I'll close it to the public and bring it back to the board for a motion.
I'll make the motion that we approve it.
Do I have a second?
I'll second it.
Just a question, since I'm new to these kind of changes.
Okay,
If we approve it, we're approving it with the caveat that was described by the other party, that things get resolved before anything
We would
moves.
make it a condition that this easement agreement be entered into. If there's a problem, then the applicant will have to come back and say,
Okay.
there's a problem, I want to be relieved from that
But-
condition.
But things don't start until that's approved, right?
That would be a condition of approval, yeah.
if that's what you
If there's
want.
Okay,
if there's a failure of the condition.
Well, I just want to make sure
Applicant would have to
what
come
we're
back.
voting on.
Yeah.
So
Yeah.
that's what we're
Yeah.
voting on. Okay.
Yeah, everybody seems to be in sync, but sometimes
Okay.
things go haywire.
Okay, so we have a motion and a second.
Mr. Diamond,
Yes.
Mr. Conway,
Yes.
Ms. Cross,
Yes.
Ms. Snow. Yes. Mr. Taylor,
Yes.
Mayor Galati,
Yes.
Chairman Ray,
Yes,
Mr. Maslowski.
Yes.
all right, good to go.
Thank you.
All right. You too.
And it is a nice design.
Thank you very much.
Everybody said that.
I appreciate your nice comments.
Good luck. Thank you. My new application, the first new application is Joseph Rosler, 106 Huron Trail. Are they here? Oh, yeah.
Just a couple of comments on the application. This property was involved in an application previously. The approval and conditions in that application are not affected by what the applicant proposes to do tonight. There was a deed recorded. Mr. Heffley prepared that deed to combine the two properties to be treated as a single property that would be designated as Lot 14. So the tax records hopefully in the future would be amended to show that.
Okay. Mr. Rosler, you gonna be giving testimony? Or-
I believe so, yes.
All right, well, we'll have to swear him in.
Okay, we'll swear in your witness. Could you please raise your right hand? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Thank you.
Is that a yes?
Yes.
Okay, thanks.
Thank you, Mr. Chairman, board members, Vern Heffley on behalf of the applicant. And this application is with regard to a piece of property at 106 Huron Trail. It's a lakefront piece of property on Bear Pond, back in those narrow roads as you go back through there. Mr. Rossler owns this piece of property, and we're here tonight to discuss a couple of improvements that he wants to make to the property. The property is in an R1 zone, 15,000 square feet required. The property is about 20,000 square feet, so it's a substantially sized piece of property for the zone. Mr. Rossler did that, as Mr. Haggerty mentioned, by virtue of purchasing the other lot, and we did a merger of the deeds. So what I did here, and I've marked it A1, which is a colorized version of my site plan. I dated it today, 4/15/25. So what we have here is in yellow, is the shaded area of the Rossler property. And this is Bear Pond down here. And this application doesn't really propose very much in terms of this, other than a bocce ball court and a dock over here. There was previously a dock was located on the property, dilapidated, fell apart, washed away, you know what happened to it. But it was located over here, closer to the side of the property. And Mr. Rossler is proposing a new dock here now to replace that old dock. So we've got a dock and a bocce ball court. That's the application. So Rossler, maybe you want to come over here and explain what we're doing in the lot.
Absolutely. The bocce ball court, again, whenever the kids, we go to my family's house and we play bocce ball, so I just again want to bring some of that memory to my house. Again, it's just kind of wood planks that are gonna border the court. It's dirt. There's nothing structurally digging into or anything around the property. It's just laying some wood and then with dirt, and then I'm gonna throw some bocce balls around. So that's the purpose of the bocce ball court.
Let's just be a little more specific about that. So the bocce ball court is basically a sand court, right?
Yes,
It's a sand court, and it has some wood planks around it to enclose it, right?
to keep the balls.
Is there much excavation required? Nothing, it's pretty much flat.
Yes,
All right.
yes. So that's the bocce ball court. Again, just wanna,
So let's just stay there for 1 second. So the bocce ball court triggers a couple of things. So this is an unusual piece of property because of its shape, obviously. So it's got essentially two front yards because it's got a front yard here on Huron Trail and also over here on Huron Trail.
Yeah.
So no matter, even though this looks like a side yard, it's actually considered a front yard. So by putting the bocce ball court here, it's an accessory structure in the front yard. The accessory structure is basically the 8-inch high wooden plank that's going around, but it does trigger that variance of an accessory structure in the front yard. And also that accessory structure would require a 40-foot setback in the front yard. It's only 27 feet. But as a practical matter, that 8-inch wooden enclosure, if you will, is the structure that we're talking about. So you know, Mr. Donegan pointed out a number of variances in here, and we're gonna discuss them, and he's absolutely right about them, and I think he wants the board to look at these, just so that the board has an opportunity to review this and that the belt and suspenders are in place, right? So, but as a practical matter, this is a very, very small structure, if you will. It's completely impervious, and it's really just a sand court. All right, so now let's move on to the dock. Go ahead.
Sure, so for the dock, the existing one was very old, so we did remove that. Again, we wanted another dock here because it's very shallow and rocky, like right here by the water, so we wanted to have a structure that comes out, so when the kids go swimming and go into the water, it's far easier and much more safer than to go into the water than just coming off here. And then the other thing I would add is, we moved it over here. There is a public access to Bear Pond, like right over here. So I didn't want to inhibit people putting in their kayaks or their boats. So I wanted to move it as far down to the property as possible so that people can still access that and go into the pond without any problems.
Okay, and so now with regard to the dock, that, again, triggers, Mr. Donegan is correct, the technical variance. The property, because it has this peninsula here, zoning officer viewed these as sidelines, as side yards. So the side yard setbacks ordinance for docks is 10 feet. So if you view this as a side yard and you view this as a side yard, these would be the lines. So there's a 0-foot setback from the side yard line if you look at it that way. So technically, probably correct. However, that ordinance is really designed for properties that go straight down the lake. And the 10-yard setbacks is so that you're 10 yards from your neighbor and that your neighbor's 10 yards from you and that you have 10 yards in between, or 10 feet, 20 feet in between. So this is an unusual piece here, an unusual shape. So if you run this out, yeah, technically there's 0 side yard setback, but as a practical matter, the dock has now been moved from what I would argue is the side of the property to a much better location. It's actually been moved further over. It's been moved away from the area that the public has access, and it's further out into the lake. So it's further removed from everything. And I think even though this is technically a variance, it's a much better location for the dock. And there's absolutely no negative impact from that. As a matter of fact, I would argue there's a positive impact. But again, it does trigger this technical variance of no side yard setback if you run the lines out this way. So that's what's going on. So that's our application, and I would submit that what we're proposing has, although these variances do exist, they are really de minimis. They have no negative impacts, and it really improves the property. And there's a lot more positive to this, to these improvements than any negative. So
The number of accessory structures.
And I think we did get the review letter from Mr. Rushke. I think we, in our testimony, addressed his couple of comments that he had on that. Obviously, the dock is going to be a permit by rule from the NJDP, and we are going to comply with that. And the existing septic field is not going to be impacted by the bocce ball court, right?
I don't know.
And no grading is necessary for the bocce ball. Okay, so those are all Mr. Rushke's comments, and we can agree to all of those.
Very good.
It looks like you've got a maximum number of accessory structure variants, not that that's because the bocce ball would be considered a structure, so. Yeah. Not by, you're on trail, it looks like, what's that, the garage? I'm just looking here.
Garage, a shed, a covered
Garage,
deck, I
shed,
mean,
and-
those are all existing.
They're all existing, we're not affecting anything really.
And I tell you, I took a look at the ordinance to see whether these 8-foot planks are actually a structure, and I couldn't find a definition of structure.
We don't have, I went to law school.
Yeah,
Okay, all right, so I looked at it this afternoon, and I'm like, well, whatever.
I think it is.
I wouldn't even consider that really a variant. I mean, if you,
Yeah,
if
no,
you, if you leveled out your yard,
doesn't really matter. It's
and you put a little
it's
landscape,
flush, you know.
you know what I'm
almost flush.
saying? I mean,
Right.
it's
almost
not
flush.
even.
And if I planted carrots in there,
Yes. It's not a-
It's de minimis.
okay,
Yeah,
Could
no
be a
problem.
sandbox for your kids.
Yeah.
Okay.
Cat box.
Then I can put box.
so, but again, Mr. Donnie is right, these are technical variances that the board should look at and approve, and that's why we're here tonight. So that's the application.
Okay. All right, any members, have any questions of this applicant? No? Seeing none? Okay, I'll open this application to the public at this time. Does anybody from the public wish to comment on this application? Seeing none, I'll close it to the public and bring it back to the board for a motion.
I'll make the motion to approve it.
Second.
Mr. Diamond,
Yes.
Mr. Academy,
Yes.
Ms. Crock,
Yes.
Ms. Snow,
Yes.
Mr. Taylor,
Yes.
Mayor Galati,
Yes.
Chairman Ray,
Yes,
Mr. Middleton.
Yes.
all right, you're good to
Thank you,
go.
everyone.
Have a good night.
Guess you're gonna keep it cut, guess you're gonna keep it covered when not in use, right?
Thank you.
There's some treats there.
Get a cat.
Okay, yeah, that's gonna be a big litter box.
You don't have to have a cat, it's gonna be every cat in the neighborhood.
That's what I was thinking.
Can't discriminate
Okay,
against
next
the raccoon.
application is Tammy Patashnik, 15 Caribou Trail. Applicant is proposing zoning for a home office for real estate and administrative purposes.
Raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
And you're the property owner?
yes.
Okay, this is a matter of really walking through the ordinance, which is 242-32, and getting confirmation that the conditions would be satisfied. What is it that you're proposing to do there?
Open up my own brokerage, real estate brokerage, which is just a one woman operation.
And your signage?
I will put a small 6x12 sign on my tree by my driveway where my number 15 is.
6 by 12, what do you mean 6 by?
6 inches.
Okay.
Sorry,
It's a
small.
big sign.
Now you have people coming to the house?
I never have anyone come to the
Okay.
house. I've been a realtor for 20 years almost. I've never had anyone. come to my
Okay.
office.
That
So
answers
I'm
my
just gonna
question.
go through the ordinance if I could. So it'll only be your office there. There won't be any other professional office at the site.
Correct.
And it will be clearly accessory to the house. Right?
I'm sorry.
It'll be accessory to the house. It'll be clearly accessory to the house that's on the lot.
I
Yeah.
guess.
Yeah.
Maybe accessory.
Okay,
It's part of the house.
it's part of the house, but it's secondary to the house, secondary to
Yes.
the residential use,
Yes.
right? Okay. And it's going to be conducted by you as the owner, of the
Yes.
business. It's not going to occupy more than 50% of the dwelling unit
Correct.
or 750 square feet. It's going to be solely conducted within the house, in the area.
Yes.
No outdoor activity on the premises associated with the use.
No outdoor.
And your sign looks like it's compliant. It's less than 288 square inches. And it contains the name of the professional and occupation. So indicate licensed real estate broker. So, all right. And gosh, I think that's it. Right, yeah. That's it.
Ain't simple. Any questions of the applicant? No? Seeing none, I'll open this application to the public. Does anybody from the public wish to comment on this application? Seeing none, I'll close it to the public and bring it back to the board for a motion.
Motion. I'm sorry.
We, Andy, the first.
I'll
Shelby's the
second that
You were a split second. faster.
Mr. Diamond,
Yay.
Mr. Academy,
Yes.
Ms. Crock,
Yes.
Ms. Snow. Yes. Mr. Taylor,
Yes.
Mayor Galati,
Yes.
Chairman Ray,
Yes.
Mr. Middleton.
Can I say yes with the caveat that it's going to be in the location you described and
Yes.
not out on the road?
Not on the road.
Right, just yes, as long as it is
Within the.
what you had said in terms
Yes.
of
And
location.
actually, my house is not even on the road.
Oh, I know, I was down the windy road.
Yeah.
I saw where your house is. It's pretty back in the woods.
Yes.
Yeah.
Okay. You're all good to go.
Thank you.
Yep, have a good night. Okay, next item on the agenda is a work session. Richie Garcia, 424 River Styx Road. Is Richie Garcia here?
With a work session, we don't swear in the witness because this is a free exchange of ideas, not binding upon the potential applicant or the board.
I mean, I went down to your side. Maybe if you want to just explain how he came here, Bill, I mean,
Sure. Yeah, as a matter of fact, there are some newer members on the board that maybe didn't know how we got here. Basically, we have a restoration ordinance, and it was probably in the around 2003 or 4, that ordinance was altered to, and quite frankly, if you have a structure built, be it the house, normally it's the house, but you have a structure, and say there's a calamity, it's the hurricane or the, fire or something of that nature. The ordinance is set up so that you can potentially rebuild that structure. And it governs whether you need variances or you don't need variances. And back at that time, and it's always indicated it was based on partial destruction. And that's the kind of the key to it. At the time, partial destruction was defined as anything that's basically less than 100% destruction. So it was very, very user friendly, and it worked real well, except we were reminded a number of times that it was contrary to municipal land use law. And quite frankly, the town could potentially be open to some lawsuits because of this. So ultimately, 2 or 3 years ago, it was changed. That definition was removed. And so it's all based on partial destruction. The difficulty is the town cannot define partial destruction, or it causes a legal issue downline or upline. So ultimately, it's kind of left to the zoning officer's discretion as to what is partial destruction. So very simply, I've gone to Cox, which most of you will, if you haven't run across it yet, you will. It's kind of like the roadmap to zoning and planning.
Bible.
And I almost, because I always didn't want to put the religious implications on, but yes. And at that point, they, in there, it indicates that, it's been kind of not standard, but a lot of zoning people in the state will say that if the foundation remains and 2 walls remain, it's partial, and it can be rebuilt without any of the variances that would exist if, to get the house building structure there. Now, what's happened is Mr. Garcia, and we've got there are a number of other of these situations where people come in and they decide they're going to redo a home, and these homes are pretty rough, and ultimately they require a lot of them. And ultimately, of course, the zoning approval is gotten, and of course, go through the foundation of 2 walls and to remain. The issue is when we get into the project, there's not as much good in there that they expected. So ultimately, in Mr. Garcia's case, I've said that, look, we've missed that point on my level, in taking the conservative view. There are a couple of partial walls left. And as a matter of fact, there were some photos that I believe were emailed to everybody. Oh, Mr. Garcia.
We got them all.
Packet here.
I took pictures.
Okay, now let me, Bill's so gracious here. This is the rule. Okay, the ordinance that Hapakong had was wrong, and it was wrong for years, and we've harped on this. I hate this area of the municipal land use law because it's not really clear. It talks about partial. There's some case law that says 50%. 2 walls, 50%. Well, that's really kind of bending it on the side for the property owner. One of the problems is, some houses may be built with a 1-foot setback. You'd like to see that change and I had a situation in Frankfurt, which is my hometown, where I represented someone who argued about that aspect with a fire in a house, and all 4 walls were there. Part of the roof was there, but the builder said, I'm going to have to really take it down because of the smoke damage and the interior damage. Frankfurt said, well, then that becomes more than partial destruction, you need all the variance approvals. Two walls, some of the municipalities accept that. I think it's a real stretch of the municipal land use law. I try to be sympathetic with applicants, but when you take it down, the law is the law. I can't change that. If you take it down to the foundation, you've lost your right. And sometimes I think people become a little too fixated on trying to rebuild exactly what was there. When in fact, there would be a better opportunity to relocate or do something to replace a foundation with a new foundation. So, you know, it comes down to, and I've got one in Stillwater either next Monday, same kind of a thing. And the question was, how much is too much? And, you know, if you take it down, you take it down. And frequently it's not the applicant's fault. It's not the builder's fault. Foundation is shot and you get in there and you say, what's my alternative? Jack up the house and drop it down on a new foundation. Sometimes the machinations you go through are a little bit overblown. But, you know, you hate to say no to somebody, but sometimes if they go beyond a certain point, that's what the law is. If a neighbor comes in and objects and appeals, we will lose.
Yeah.
We will lose.
Well, I mean, I get what it says, but listen, he could rebuild the house, keep those two walls and get that far and then take those two walls. I mean, it's kind of a,
It's a silly exercise,
Yes.
frankly, it really
Yeah.
is.
I mean, I went down and looked at this. I mean, this,
Yeah.
obviously, you know, the construction 30, 40, 50 years ago was not what it is today. I mean, you
They
don't know
were
what you got.
bungalows back
Yeah,
then.
you get into it and all of a sudden, you know, I mean, I'm of the opinion that if you're not expanding it and you're not keeping on the same foundation and if you gotta, none of this is worth saving, Bill, you know what I'm saying?
Yeah, no, I had one at my community where they jacked a house up, built the foundation and dropped it down. So, you
Yeah.
know, people would go through
Yeah.
a lot to,
Well, I mean, at this point here, just to try to save whatever, I mean, it's just gonna be a show. It's not gonna be, there's structurally, there's nothing here that you could hang your hat on, you know what I'm saying?
Bill, this remains in the same footprint, correct?
Yes.
right.
I mean,
The board-
he's done some foundation repair, but it's not expanding one inch, it's
Yeah,
going
the
exactly.
board take a position, that's fine.
Yeah.
I just
Okay.
tell you what
Yeah,
the law says, whether it's a sensible law or not, I just tell you what it
well,
is.
there's no way he can make it any, listen, I get it, if it's a foot off the property, you would like to,
Yeah,
if it's possible to get more, but this here looks kind of like smack right in the middle. I mean,
There's one, it's very, well, actually, there was a part of the house that's been removed and won't be coming back.
okay,
There was a little expansion in another area, but it did not trigger any variance.
okay,
And I look at that way, it's the same as if I have a really good house that's in really good shape and they want to do an addition, if it doesn't trigger variances, I get, you know, I approve.
Sure.
it. So that was my mindset
Sure.
in there.
I mean, my opinion is if it's not gonna go outside of what you're there, then move ahead, tear it down, take I mean, it's foolish to try to even work with what's there. It's totally garbage.
Try to say that's
Yeah.
ridiculous.
If there was something historical or something, then you gotta do what you gotta do, but there's nothing. You know,
I have to agree, those structures back in the fifties were substandard, and he's bringing it back to,
up to
up to
snuff,
code.
Yeah,
okay.
so I
The board
think
can
it's
give Bill their guidance and,
yeah, I would say.
I think it's a benefit.
Absolutely. I would just say let him move forward with what he's doing. I mean, I don't see a need to save that. So as long as you're not expanding it,
I won't.
that's it. Bill will keep an eye on it.
If you're not triggering any variances, I don't see a problem with it.
No, technically, I'm gonna remove and put it back together. That's it.
All right, so anybody else? I mean, any?
I just have a
objections?
question. Bill, did you say it was you're comfortable with people leaving two walls and the basement, did you say?
Well, there's the personal side and the technical, side, right?
Yeah, I'm just
The
trying,
personal side is I love the foundation, I mean, you know, but
two walls and a
basically,
foundation.
I'm purely riding on Mr. Cox's shirt tails, you know, because it, you know, I understand the town cannot dictate what's partial, you know,
It's up to the board to determine
Yeah.
what's partial.
And listen, we've seen it, you take the wall and you stand it against a tree, and when you put it back up, you put that one, and then once you get your inspection, you tear it. I mean, it seems to me like a waste of time. You know, I mean, to move ahead with,
I wish the statute would be changed.
yeah, I mean, how can we change? We can't change it. Is that a state statute,
Yeah.
Bill?
What's that?
Is that a
Oh, yeah,
state
that's the
statute?
municipal land use.
So we can't,
No, and you adopted your ordinance in accordance with this. Yeah, actually, your ordinance is verbatim what the statute
Mm.
says now.
I'd like to agree that in the interpretation of the Cox book, the benefit is to replace what was an act of God torn down by fire or some other thing. And I understand the
Yeah.
consequence of the statute, but I think the intent was to give the opportunity of the homeowner or to rebuild the house back to, modern
That's
standards.
fine, as long as Bill has guidance with what the board's position is.
all right, I agree with you, you know, listen,
I think that's the intent of
Yeah.
the Cox book, and I understand from my interpretations and going to the meetings was the reasons that some of these issues were brought up in the interpretation was to prevent people who were, I don't want to say dishonest, less than credible, forthcoming in building something that shouldn't have been rebuilt.
But yeah.
But this isn't that
What
situation.
you're trying to avoid again is, you got a less than a 1 foot setback and somebody could have a 20-foot setback. Well, you'd like to provide a greater setback if they're gonna take the house down, it doesn't, we want to have a better relationship to the property and
I
the zoning
agree.
ordinance, so then,
And it's to the
where-
benefit of the town.
well, yeah, it's for the benefit of everybody. Now, if that's not the case and, your required setback is 20 feet and he's 19 feet, well, what's the difference?
yeah, I think it should be a case by case. I mean, obviously, we have that. If you're a foot and you want to rebuild, well, then and you got room to go the other, well, maybe we have to
Yeah,
revisit, you
Yeah.
gotta move it over a little bit.
And
This case is simple.
sometimes, all of a sudden it
Yes,
begins
yeah.
to grow.
So I think as long as it's same size, same location, nothing changes, I don't have a problem with it.
If that's the board's consensus, then that's the board's consensus.
I think that's the consensus,
I appreciate it.
all right?
So
Thank you.
what would be the next steps then?
The thing is, the board can't make a decision on this. I've kind of gleaned the attitude of the board, and ultimately, I'm just gonna say we're good. And, that is partial, we still are inside the partial destruction.
I mean, that thing, what's there now, looks like a kid built it, like a tree house, I mean, it's amazing it's still standing. But, all right,
Been
so-
making for almost 20 years,
Yeah.
right?
Oh,
So
it's been a
it's
at least,
it's been a problem for the town, and I'm
Yeah.
just trying to make it happen.
all right, so you got your,
Guidance,
all right,
So I'm going to take whatever is there out and then build from scratch.
subject to,
the bill, keep an eye
subject to
on it.
Bill's
More
review.
than welcome to stop by anytime.
All right,
All right?
all right, very good.
Thank you.
Thank you.
Enjoy the rest of the night.
You too. Okay, at this point, I'll open the meeting to the public. Does anybody from the public wish to comment on any land use applications or? No, seeing none. I'll close it to the public, bring it back to the board, and welcome back, Judy.
Thank you.
You're up.
Motion to
All
adjourn.
right, we're done.